Good morning, everyone. That works. Welcome to the Appeals Court. I am Justice Rubin, and both you and I are lucky because to my right is Justice Grant, to my left, Justice Hodgens, two of my outstanding colleagues. We will be hearing, actually, how many cases will we be hearing? We will be hearing 6 cases this morning. The rules are as they always are, which is 15 minutes per side with no rebuttal. One day they'll let me have rebuttal, but for now, no. We have read your briefs with some care and are familiar with the facts of the cases. So my recommendation is that you get right into your arguments, but it is your time and you may do with it as you wish. If any parties are dividing their time, they should let us know at the outset what the time division is, although we may have notation of that also. And I think with that, we can begin with our first case, number 25-311, Commonwealth versus Young. Is that right? That is right.
Good morning, Your Honors. My name is Daniel DiMaria, appearing for Jonathan Young, the appellant. May it please the Court, this case asks whether Article 14 permits police to stop the first person they encounter after hearing gunfire, escalate the stop without individualized suspicion, and then justify an exit order and pat frisk based on assumption rather than articulated danger. The answer, based on well-established case law, is no. Gunfire shows a crime occurred, not who committed it. In this case, police did not have the particularized, individualized suspicion which Article 14 requires. Officers had no suspect description, no vehicle description, no direction of travel, no observed criminal conduct, no narrative of facts. All they had was proximity, and proximity alone describes a very large category of persons and simply fails to survive constitutional scrutiny.
But as the motion judge put it, they were in the right place at the right time. It's kind of an unusual case where they didn't have to rely on any reports from witnesses or anonymous tips. They were there, and they heard the gunshots, right?
Yes, Your Honor, but they were some distance away. When I say some distance, they had to make 2 left turns to get to the vehicle. They saw the vehicle driving at a high rate of speed for about 50 yards before the car pulled over, turned its headlights on. I would submit those facts in and of themselves are as consistent with innocent behavior. Someone hears gunshots, they panic, they flee, and not simply the marks of a suspect. Additionally, as the motion judge recognized, there's a cemetery, there were alleyways where the police officer simply could not look down and see, and there were some other vehicles around. And so I would submit there simply wasn't, this stop cannot survive constitutional scrutiny.
What about the bounce of the car? Isn't it the one where the car bounced and then it pulled over and stopped?
That was the testimony, and that's what I refer to as speeding, Your Honor. And again, I would submit that is as consistent as someone saying, holy smokes, there's a shooting, I need to get the heck out of here. And it could just as easily point to an innocent bystander as a suspect. Now, I would submit the exit order is even more problematic. As the court knows, for an exit order, you need a reasonable belief of danger grounded in articulable facts. When the police arrived at the vehicle, both occupants had their hands raised, window open, no furtive movements, no threats or resistance. The motion judge found that at least one officer drew his gun. One officer clearly testified he did not draw his gun. And I would submit there simply was no reasonable belief of danger in these circumstances. You have 3 officers, 2 suspects with their hands up, window open. The police absolutely should have and were constitutionally required to ask them questions, they couldn't immediately issue an exit order. We know from the body cam footage this all took place within 34 seconds from the...
When you say the police should have asked them questions, if the police asked them questions and nothing suspicious turned up, would the police then just be required to let them go on their way?
Yes, Your Honor, that is what the Constitution would require. They had their hands up, windows open, simply no reasonable belief of danger.
The one black latex glove seems to undermine your argument pretty strongly.
In 2026, I would agree, Your Honor. In 2020, during the height of COVID, I would say wearing a glove was not uncommon.
One glove? I mean, I saw a lot of people with gloves during COVID. I don't remember seeing people wearing one. The officer testifies it's consistent with handling a firearm and not wanting to leave fingerprints on it. And they were already, if the stop was lawful, there's already reasonable suspicion that they were involved in that firearm crime. So I don't really see why when you add the glove to it, why you don't have reasonable suspicion.
So reasonable suspicion is, for the exit order, Your Honor, we need a reasonable belief of danger.
Reasonable suspicion that there's danger, yes, I agree with that.
And I would submit a glove even in and of itself wouldn't...
It's not in and of itself. It's the car that fled from the scene. You say it's equally consistent with a person just fleeing the scene of the crime or of a gun crime, but it is someone fleeing the scene and attempting to avoid police, and then when they have their hands up, they have one latex glove on their right hand. You know, so it's not any of these things standing alone. It's all the facts and circumstances, right? I mean, that's what we have to look at.
That is correct, Your Honor. I would argue, though, that even if the glove, if we assume, and Your Honor is probably correct, that the glove, you know, was incriminating and shows the person may have been armed, that in and of itself cannot substitute for an articulable risk.
That is articulable. You just articulated it. The glove was inculpatory and suggested that he might have had a firearm. That's articulable.
But we still need the reasonable belief of danger. One officer didn't even take his gun out, so he was...
That's our test? How many of the officers take their gun out? I don't see that as having anything to do with this.
I simply would disagree respectfully, Your Honor, that there was no reasonable belief of danger. But even if there was, the pat frisk is the clearest violation. Now, less than 10 seconds elapsed from the time Officer DeGrave arrived at the passenger side door, from the time he removed Mr. Young from the vehicle, less than 10 seconds. And as we know, we need specific, articulated facts that this person is armed and dangerous. So being armed, which the glove may show, does not show that Mr. Young was also dangerousness. The Commonwealth relied on nervousness, lack of eye contact, a single glove, and alleged hesitation exiting the vehicle. I would submit this is a deer-in-the-headlights scenario. It all happened so quickly, he didn't realize what was going on. But again, we have less than 10 seconds. There's absolutely nothing to show the armed and dangerous part. And so I would submit that at a minimum, the pat frisk fails. Certainly, I would also argue the stop would fail. I don't think Your Honor is as persuaded about the exit order, but I think all in all, this was not a constitutionally valid stop, exit order, or pat frisk.
How can we decide the ineffective assistance of counsel issue without a motion for new trial?
Oh, that question, Your Honor, is easy. So, as I argued, the court excluded hearsay that Mr. Young fired the gun. So we know that at the point that defense counsel put a motion in limine, he believed that hearsay should be excluded, completely expected, completely reasonable. Then the police officer volunteers the hearsay statement unprompted. Defense counsel still does not object. During a recess, the judge raises the issue sua sponte. Counsel still declined to act, and the judge ruled the statement was in evidence. And this is all part of the record, Your Honor.
Let me ask you this. If the defense attorney had objected and the judge had stricken the testimony, she also said Mr. Young did too, would there still have been enough to go to the jury, evidence between the glove and the proximity and the driving of the car and the whole thing? Would there be enough for the case to go to the jury?
Certainly not on discharge of a firearm, because the glove and the case law does say when there are two perpetrators with an equal chance of committing a crime, the conviction cannot stand. That's Commonwealth versus Mullen. So I would say with the discharge of a firearm, the glove and the speeding and the recovery.
How do we know that trial counsel didn't make a strategic decision to refrain from objecting, because had he objected, and even assuming the judge moved to strike, and we have to assume the jury obeys the judge's instructions, the defense attorney didn't want to object in front of the jury? Why is that not a strategic decision that we need to have Judge Zagantori have an evidentiary hearing on and decide whether or not it was below the variance standard?
I would argue it's apparent from the record, the exclusion, the violation, counsel's explanation was directly on the record. The prosecutor's use and the jury's questions, all those facts are in the record. And I would say this was such a harmful hearsay statement. And if defense counsel had simply blurted out objection, presumably the judge would have stricken it. It would not really have drawn.
So where the defense attorney didn't say objection, was the judge obligated to say, hold on, you're not objecting, that's ineffective, I'm going to strike it anyway?
The judge was so concerned he raised it during the first available opportunity outside the presence of a jury, and it's absolutely inexplicable, and there simply cannot be any strategic reason.
What should the judge have done, is what I'm saying. Did the judge do anything wrong?
No, the judge raised it sua sponte and gave defense counsel a chance to object without the jury being present, and for some reason, defense counsel still did not take him up on it.
When you say for some reason, don't we need to find out what that reason is?
I would say no, because the excluded hearsay established elements of both offenses, the discharge of a firearm and the loaded firearm. And so no strategic reason, there simply is absolutely no strategic reason to not object to hearsay, which establishes elements of two different offenses, when that was the only evidence. There's no other evidence of whether he or Ms. Sturgis discharged the firearm. And so I believe that under Commonwealth versus Mullen, if it could have been either one of them, an acquittal would have been, or a required finding would have been compelled.
Am I remembering correctly? Did you try to get an affidavit from trial counsel?
I did not, Your Honor.
Okay.
I thought it was so clear on the record, I did not go that route.
You know, it's interesting because in addition to the discussion at sidebar where the judge seemed to be sort of prompting defense counsel to move to strike or say something, the jury came back with a question.
Exactly.
So even at that stage, defense counsel didn't say a word, which to me suggests that counsel had something in mind, that was sort of the last chance to say, well, geez, Judge, now that this has come up as a question, I'm going to ask that you instruct the jury to disregard that statement because it was just a mistake on my part, you know, or whatever. But it didn't do that. So that says to me that the lawyer must have had something in mind there, or it was just complete neglect through the entire course of the trial. So which is it? And we're kind of left wondering.
Again, Your Honor, I would say it's complete neglect. No reasonable lawyer allows excluded hearsay to establish an element of the offense, especially when there is no other evidence, especially for the discharge of a firearm. Boothby and White both tell us that the case should be reversed under these circumstances. And I will note as well, the prosecution relied on it in closing argument. This really was the linchpin of Mr. Young's conviction on the discharge and possibly also on the loaded firearm case.
Do you have any supposition for what this lawyer meant when he said, I didn't want to object in front of the jury? He says, I was going to object at sidebar, and they are at sidebar. And then he says, but I haven't done that. Period. What do you think that meant? What?
I think
Seems
he's
crazy.
Exactly, Your Honor. I think he was completely confused. Now, perhaps in front of the jury initially, if he thought he had to, that it was
Okay,
not.
but he's at sidebar, says he was going to object to sidebar, and then instead of saying, so I object, he says, but I haven't.
Exactly, and I would argue, Your Honor, that in and of itself compels reversal. I think this is a clear cut for reversal, either on the suppression issue, and certainly, if not on that, on the ineffective assistance of counsel issue.
There was one inaudible portion of the closing where it looked like counsel was on the verge of referring to the statement of the driver, and it just got cut off as inaudible. Any effort to try to reconstruct what that was?
I did not, Your Honor. I wish I could assist the court. I don't think I caught on to that.
Your time has expired, but if there are more questions, I see none. Thank you. Very good argument. We will hear next from, I'm not sure who we'll hear from. I guess we'll hear from Mr. Pally, if I'm saying that right, and if I'm right.
Morning, Your Honors. May it please the Court. Malcolm Pally with the Commonwealth, with ADA Sarah Lewis, and I would also like to acknowledge the trial prosecutor, Charles Marshall, who is here today. The Commonwealth asked this Court to affirm the denial of the motion to suppress and the defendant's convictions. Police lawfully responded to shots fired. The motion judge correctly ruled that the stop, exit order, and pat frisk were constitutional. Trial counsel was not ineffective, and the convictions were supported by strong physical evidence. Turning first to the motion to suppress, this case begins with officers personally hearing multiple gunshots in rapid succession while patrolling a residential neighborhood known for firearm violence. This was not a report or a tip, it was directly heard by officers. Within seconds of hearing the shots, the officers drove towards the area where they believed the shots originated. As they entered Sumner Street, they observed a single white vehicle rapidly exiting a nearby parking lot. The vehicle was traveling at a speed higher than normal and visibly jumped the curb as it left. Crucially, there were no other vehicles and no pedestrians in that area. This was the only car observed leaving, which officers reasonably believed to be the scene of the shooting. The vehicle then turned onto Annapolis Street before abruptly pulling over less than 50 yards from that parking lot and turning off its headlights, going dark. Based on their training and experience, the officers reasonably interpret this as evasive conduct, an attempt to avoid police detection. This court also recognizes that when officers hear gunfire, the seriousness of the offense and the immediate threat to public safety significantly heighten the reasonable suspicious calculation. Here, the officers were duty-bound to investigate shots fired. All of this occurred within 1 minute of the shots being fired, within one block of the suspected location of the shooting. This court has held that temporal and geographic proximity are especially probative when the timing is immediate and the distance is short, as it was here. Viewed together, the violent crime, the immediacy, the lack of alternative suspects, and the evasive conduct, there was ample suspicion to stop the vehicle. Once the vehicle was lawfully stopped, the exit order was justified on independent grounds. The officers reasonably believed the occupants might be armed, given the suspected shots fired moments earlier. As Officer DeGrave approached the passenger side, the defendant appeared extremely nervous, avoided eye contact, and was wearing a single black latex glove, an observation the officer associated with an attempt to avoid detection of firearm handling. The Constitution does not require the officers to gamble with their safety, particularly in the context of a suspected shooting, and the totality of the circumstances justified the exit order here. Second, the exit order was independently justified by a reasonable suspicion of criminal activity. When police reasonably suspect a violent felony, greater intrusion than a routine traffic stop is permitted. Here, this was a reasonable measure to prevent escape before concluding a threshold inquiry. The pat frisk followed naturally. The officers were investigating a shooting that had just occurred where the defendant was found in close proximity. He failed to comply immediately with exit commands, and the officer had to physically guide him out of the vehicle. Taken together, these facts provided reasonable suspicion that the defendant was armed and dangerous. The pat frisk was lawful, and the firearm was properly admitted. Turning next to the ineffective assistance of counsel.
Can I stop you before you get to that? What is the evidence in the record of knowledge that the gun was loaded?
Yes, Your Honor. First, the knowledge would be basically from the inference of possession that...
Surely that's not enough. Possession of a gun doesn't always equal possession of a loaded gun. How could it?
Well, yes, Your Honor, that would be the common sense inference that one would check.
Anyone who has a gun is now also guilty of possession of a loaded gun if it's loaded. I don't think that's the law. I mean, I've had some of these cases before, I don't remember, but I think there has to be some evidence that they knew the gun was loaded beyond mere possession.
Yes, Your Honor. First and foremost, that the prints from the defendant's left palm were found on the magazine.
All right, let me ask you about that. That does seem to me to possibly support this. I couldn't tell, I don't know if there's any way to tell or if there are photographs or something in the record that I missed. There was a print on, I guess, the lower right-hand side of the magazine, something like that. But what I can't tell about that is, does that mean the bottom, which is exposed all the time because it's, the bottom of the magazine becomes sort of the bottom of that handle area? Or does it mean on the side of the magazine that's inside the gun? Do we know?
I believe, Your Honor, I can't point at the reference specifically, but I believe the record shows that it was the side of the detachable part of the magazine, which would suggest some prior relationship with that magazine prior to any just a one-off touching.
Beyond merely touching the bottom of it
I
once
believe
it was
that
inserted
is
in the
the case,
gun?
Your Honor.
Okay.
Secondly, the black latex glove, it suggests some type of knowledge that the firearm was loaded, given that it often is associated with an attempt to avoid leaving gunpowder residue on the hand. And furthermore, the evasive conduct, nervous conduct, all indicate consciousness of guilt, having discharged the firearm.
But of what?
And furthermore, if the defendant was unaware that the firearm was loaded, he surely knew after each successive pull of the trigger, given that there were 5 or 6 shots fired.
I have a question about the knowledge that it was loaded. I think I've seen cases that say that where somebody has a gun stuffed into their pants, there's an inference that they'll know whether or not it's loaded before they stuff it into their waistband. Do you have any cases that talk about, the findings are that it was on the right side of the defendant's hooded sweatshirt. I don't know whether that's in the pocket or rumpled up in the I don't know do you have any cases about whether or not finding a gun in a sweatshirt that the defendant is wearing creates an inference that the defendant would know whether or not it was loaded?
I can't point to a specific case on that point, Your Honor, off the top of my head, but it was important that the firearm was located in the same side of the pocket as the glove was on, indicating that the firearm was in that gloved hand before being placed into that right-hand pocket.
You can go on with the ineffective assistance if you would like. I'm sure
Thank
we
you,
have a
Your
lot of questions about that.
The defendant next claims ineffective assistance based on counsel's failure to object to a brief, isolated, and unprompted hearsay statement on cross-examination. That claim fails under both prongs of Seferian. First, counsel's decision was strategic, not deficient. The record shows that counsel litigated the issue, the hearsay issue pre-trial, and was fully aware of the statement. When the officer made a brief, non-responsive reference during cross-examination, counsel made a measured decision not to object in front of the jury. Counsel explained that decision at sidebar.
Well, I just want to make this point, because this has been said by both sides now, that it was a non-responsive answer. I'm not sure that that's really fair, because the question was open-ended, right? The question was, well, there are two questions. Your testimony here today is that Ms. Sturgis was charged with discharging a firearm. Yes. That's because she told the police officers that she had been firing off the gun. She also said Mr. Young did too. So when a lawyer asks a question, that's because, it kind of opens the door to the witness to.
Yes, Your Honor. Here, the witness made a comment which was a very brief and isolated.
This briefness thing that I hear all the time in Commonwealth briefs really does nothing for me. This is a critical piece of evidence. Yes, it's one sentence, the critical one sentence. So the fact that it's brief really isn't the question. It's the substance of it.
Yes, Your Honor. That it was a substantial statement here, but here the trial counsel elected not to object to this remark.
Okay, but your brother's point is, and that's manifestly unreasonable, and I have a hard time understanding. I understand you say he didn't want to object in front of the jury. That, I guess, could be a tactical decision. It's a pretty bad testimony for his client. But then at sidebar, he's invited to object, says, I didn't want to object in front of the jury, who he's no longer in front of. I was going to object at sidebar, but I haven't. What could that possibly mean?
Yes, Your Honor. I believe that trial counsel may have stated that he was going to come to sidebar, and that he was definitely going to object, but I would have to confirm on the record with that. But the decision not to object makes more sense when placed in the context of trial counsel's strategy, which really the theory of the case was that it was Ms. Sturgis and not the defendant who fired the weapon. In fact, defense counsel...
That's the defendant's theory.
Yes.
Then the objection is critical. Without that, if all she said was, I fired the gun, you might get acquitted if the Commonwealth was foolish enough to put that sentence in on its own, although I suppose the other side might have, although then there's doctrines of completeness and whatnot, I don't know.
Yes.
But knowing that she was not supposed to testify to the second sentence, the Commonwealth put her on the stand, or put the officer who talked to her on the stand, and the statement, she said she did it, is helpful. So why wouldn't you object to the part that totally undermines your theory of the case?
Yes, Your Honor. I believe that would have been a strategic decision just to avoid drawing further attention to that remark.
Okay, but objecting in front of the jury, do you have a theory for why he wouldn't object at sidebar when invited to do so?
Your Honor, perhaps it was simply, again, not wanting to remind the jury of that fact and hoping that, given that the remark was isolated, that in the context of the trial, perhaps the jury attention would fade or misremember that remark, and that would not play as large a role in deliberations. I think, secondly, that it also is placed in the context of the fact that there was overwhelming and ample evidence towards the defendant having discharged the firearm. This takes on a more understandable approach by trial counsel, and also shows how there was no prejudice that created a substantial risk of a miscarriage of justice. The firearm was recovered from the defendant within 1 minute of the shots being fired. Prints from his ungloved left palm were on the magazine. He wore a single black latex glove on the same side of his body that police recovered the gun from. The slide was locked back on the weapon, indicating recent discharge, and shell casings recovered from the scene matched the firearm. Evasive conduct, nervous conduct, and the black latex glove all indicated a consciousness of guilt. Given this independent physical evidence, the defendant cannot show that the hearsay statement deprived him of a substantial ground of defense or affected the verdict.
Do you think we need an evidentiary hearing to find out what was on counsel's mind?
I think that here the basis of the ineffective assistance claim is indisputably on the record, given trials counsel's actions and strategy, both at the motion in limine, at the sidebar, and during trial. So I believe here that the basis is on the record, and this court can and should decide this issue.
I'm with you up to a point, but when the jury comes back with a question about this very testimony, it's sort of the last chance for the defense counsel to try to mitigate whatever damage has been done, and he says nothing. So I'm wondering, was there a strategy in place here that it's just not evident?
I think here, Your Honor, again, it would have been the same strategy. I don't want to speculate as to what was going through defense counsel's mind or the jury's deliberations, but again, avoiding drawing attention to it, and it would have been a reasonable inference to think that perhaps the jury was not unanimous on focusing on this, or simply wanted to clarify or get help in remembering what this issue was. And here the judge's instructions that the jury's evidence is closed and that the jury's memory should guide them, mitigate this issue. This jury note doesn't establish prejudice or even centrality, just some sort of question or clarification about that. Turning last to the sufficiency of the evidence here, the evidence was more than sufficient to support the convictions. Under the Lattimore standard, the question is whether any rational juror could find the elements proved beyond a doubt. This includes circumstantial evidence and the inferences drawn from this evidence. And here the answer is clearly yes, given the proximity, the recovery of the firearm on the defendant's person, the lack of any transfer witnessed, the gloves, and the defendant's conduct. In addition to the ballistics matching the ballistics found at the scene matching the firearm. For all these reasons, the motion judge's rulings were correct. The defendant received effective assistance of counsel, and the verdicts were supported by overwhelming evidence. The judgment should be affirmed.
Thank you very much. Your time has expired. Very good argument.
Thank you.
From both sides, and the case is submitted. The next matter is number 24839. This is Commonwealth versus FEB, although I'm sure I'm mispronouncing that. And we will hear first from Attorney Renaud.
Thank you, Your Honors. Suzanne Renaud for Andy FEBRES. And to be honest, I don't know how to pronounce it either.
Can you move the microphone?
Is that a little
yourself?
better?
Yeah, thank you.
Your Honors, this is to start with the sufficiency issue. It's obviously applying well-known principles of law, but I think that you have to look at the facts of the case specific to this case. And obviously, there are parallels to different cases throughout the Commonwealth, but the ones that this parallels most closely are the C, Baez, and Baxter line of cases, where there is clearly this idea that when somebody is a getaway driver, which is sufficient under Zanetti, it nonetheless needs to still be proven the two elements, in particular the intention element. And in those cases where you don't have very much evidence, and there's minimal evidence on this record, it pushes it to accessory after, if anything, rather than an actual person who is a joint venturer for murder. So I want to start, if I may, talking about Carlton, which is obviously the newest case in this line. But Carlton has a lot of similarities with Sanders. So I think that you can take a look at those two cases together and understand how they differ so much from this one. Because for one thing, those are drive-by shootings. Those are shootings that happen from the car. And the part of Sanders that was repeated by the SJC in Carlton had to do with the difference between a pedestrian shooting versus one that took place from a car. This is a pedestrian shooting. In addition, in Carlton, there had been evidence that there was a laser that the defendant could see before any shooting even started. He had the opportunity to move the car away from where the shooting was going to happen. He knew that shooting was about to happen. This case is entirely different, where you have Mr. FEBRES stopping the car, and I want to say that when he stopped the car, he did it because he was told to. I know the Commonwealth suggests in his brief that there had been no talking in the car. That's not true. Mr. Howard knew Cutta, in part because he heard him talking. He testified multiple times that he was giving directions and he was telling Mr. FEBRES where to stop. So this wasn't something that Mr. FEBRES already knew. It wasn't something that he was doing reconnaissance, unlike in Carlton.
Let me ask you about, so your theory about distinguishing between the cases where the gun is shot from the car versus the people get out of the car to shoot.
Yes.
What about the fact that the bullet casing is found in the car, and the video seems to show that inferably Maston started shooting right when he was getting out of the car?
So it's still a pedestrian shooting. He's still on his feet. He opened the doors. It wasn't a shooting that happened because of where the car was positioned. So in Carlton and in Sanders, the car was positioned in a way so that there could be access to the other car where the victims were. Here, once the car is stopped, the fact that he immediately started to shoot, it didn't shoot out the window. He shot with his feet on the ground and the door open. And yeah, there's recoil in a spring action that leads to the shell casing getting back into the car. But the fact that that happened doesn't turn this into a drive-by shooting. And then there were, I think, 10 additional shots fired by two people that clearly happened from that moment on. But even if you assume that that now means that Mr. FEBRES has knowledge of the gun, it wasn't pre-existing knowledge, which is different than Sanders. I will kind of say that there is some dicta that says in Sanders that he must have known that these guns, all three, were going to come out at the same time. I'm not sure how persuasive that is in this case, but Carlton doesn't have that language, doesn't repeat it. But we do know from Mr. Howard, and this is, I think, important to know, it's not like these two people had their guns out in the car. He didn't see them, he didn't know.
Let me ask you about the timeline. So the shot spotter goes off at 7:45. And for a few minutes before that, they're driving en route from Annunciation Road to Westminster Street. For a few minutes before that, they're waiting in the car
Yes,
after the defendant gets back in.
yes,
For a few minutes before that, the defendant gets out of the car briefly.
yes.
At 7:38, he gets the text message that says, yo.
No, well, yes, he did get that text message that says
He
yo.
responds, yo.
He does not respond. He did not respond to those text messages.
He responded,
He did not. To the hello, it's called hello, and he did not respond to those text messages.
so can the jury infer from the fact that that came at 7:38 and the chronology of events as described by Howard, and the fact that Howard said it was dark, that yo came from either Maston or Campbell and was an arrangement to meet in person to discuss the crime?
Your Honor, that involves so much speculation and jumping to many conclusions that any of these people are involved. And I would also say, although I don't believe that the Commonwealth ever proved that Paul Thrashing was Mr. Maston, I'm sorry, I'm getting people confused. That was their theory, is that was the name that he was attributed to in Mr. FEBRES' phone book. But putting that to the side, let's assume, this is, again, I think, a lot of layers. Let's assume that Mr. FEBRES had talked to these, he went over to the dumpster and he talked to the two shooters. And
Well, Howard doesn't say they went to the dumpster. When he's asked about the dumpster, he says he doesn't know or he
doesn't
didn't
know where
see.
he went. But
Right.
I think for the purposes of this, let's assume that he went over and encountered these two people and they said, hey, we want to commit a crime with you. Or alternatively, the 3:12 p.m. somehow ties this all together, that there's some kind of scheme or code. This is the same problem that you hit in C and in Baxter, which is that, okay, there is some indication, maybe, that they were planning on committing a crime. But the fact that it was a lethal crime and a murder were not established on the record in those two cases, irrespective of in C that there was reconnaissance that was happening beforehand, irrespective of in Baxter that they were clearly going to scope out where somebody was. The fact that somebody might be committing a drug crime or an assaultive crime or some other kind of crime doesn't get you without a lot of speculation to the point where there was a knowledge of the plan to murder. And I think that's really...
Assume for the sake of argument that at 7:38:45, the defendant responded, yo.
But he didn't. I can't accept that as a premise because he didn't respond.
Record Appendix 48.
I'm sorry, I don't have it in front of me. My understanding is he never responded.
To the yo, I thought he got a yo, responded yo, and then 20 minutes later got a how you doing? Maybe I'm wrong about that.
In Your Honor, I can look it up, and I am very apologetic if I have this wrong, but my understanding was that it was two yos from the same text message, and then it said, yo, where you at, or something of that nature. I think that it's in...
Well, so what can we infer from the fact that at 8:06, so this is 20 minutes or so after the shooting, he gets something from Newside Hallows saying, yo, you good?
I don't think you can infer anything from that about...
Well, what about the fact that Maston ran separately from the shooting scene from the defendant and Campbell?
So, Your Honor, if you would just give me one moment, please, because although I don't have the record appendix in front of me, I think that I'm sorry, I think that I am now getting very confused about that factual issue, and I apologize to the court. And if I am wrong, I will certainly, I apologize in advance, because I'd be surprised that I got that part of the record wrong, but my apologies. But I think here's the problem. We don't know who that person is, and I know the Commonwealth says in their brief that, oh, it is an unknown number, or they're talking about the other one. These are not... They're just not numbers that the Commonwealth associated with any of the parties here. That's all it is, and that's all that's before the jury. The fact that somebody is texting you, it's not even text, it's a Facebook message, saying yo, or yo is just an introduction. Yo is just saying, hey, how you doing? The fact that somebody says afterwards, yo, you good, in keeping in mind that the judge was wrong in his motion that he said, yeah, I heard something, that's not part of this record that's in front of the jury. The fact that somebody says, yo, you good, could mean so many different things. It does not mean that, let's say this person knew that Mr. FEBRES was driving these other folks and then heard that they killed somebody. That doesn't mean that Mr. FEBRES knew that there was going to be a shooting. There's just too many ifs about what those text messages are going to mean. Now, as far as the people scattering in different directions, that all happened after the fact. So what we're talking about is Mr. FEBRES' intention.
What about the rental car? I mean, doesn't that before all of this is set in motion, doesn't that kind of set the stage for there's a mission underway, and it's a special mission because we have to make sure that this vehicle is not connected to us directly?
The word mission is a creation of the Commonwealth, Your Honor, so I want to just kind of put that to the
I just thought it up myself just now. But.
Oh, okay. Well, they came up over and over again during like the arguments. Oh, I want to address both issues, if I may. So the issue with the car, people rent cars. He didn't have a car. He didn't have a license. He had a plan with his then girlfriend. He was paying for it, so it was easily traced back to him, and he didn't even need to bring it back. But even assuming that you're right, that there's something nefarious about it. It doesn't get you to the point of intention to murder, or a plan to murder, or knowledge that a murder was about to be committed that he knew before or during the crime. So those are two things. As far as what they did after the fact, the Commonwealth even said somewhere on the record that it was basically, it was just stupidity to leave the car where they did. They stopped at a tenth of a mile away from the scene in a warren of areas where Mr. Howard, at least, I don't know how much he was clearly very agitated at that point, but said that he was told that Mr. Febbs was being told to keep going. Mr. Febbs basically stopped being the getaway driver, and people just left. The fact that they went to different directions, and I think Mr. Maston ended up heading back towards the scene of the crime, if I'm remembering what was said during the closing argument correctly. The fact that they scattered in different directions and went to Ruggles doesn't suggest a plan. It suggests that that's the place where people are trying to get away. Ruggles, obviously, is a hub. And that's why different people, Mr. Howard, had no idea any of this was going on. Now, and if you're going to talk about there being a plan, why are you bringing Mr. Howard when there's obviously time to get him out of the car? So there are so many different questions here. I think you have to go back to the fact that before the crime was committed, there is almost no evidence, aside from piling many, many, many inferences from a couple of text messages, that Mr. Febbs knew anything about what was going on. And after, he was not, there's nothing in his behavior. This isn't like in Bonner where he goes and kicks the guy or gives encouragement. He fled for a moment. He fled for a moment. He wasn't there on the scene when these people were shooting. His actions of dropping them off didn't make them kill. They were going to kill anyway. His action of picking them up didn't make them kill. They had already done it. He wasn't facilitating them, helping them, or encouraging them. He was there. At most, what he was doing was giving them, showing intent to help them get away.
If we agree with you, is he guilty of a lesser included offense?
The only lesser included would be manslaughter, because he was convicted of second-degree murder. Accessory after is not a lesser included. It's something that would have to be separately indicted.
What's the element that's missing?
I believe it's in Watson. It talks about how they are two separate offenses, and I might have put a citation in.
We can figure that out.
But they are definitely not. It might be Baxter, because in Baxter and C and Baez, the court did grapple with that issue, and they said, these people might be able to be convicted of accessory after. But the court did not exercise its 33E authority to find the person guilty of second-degree murder or manslaughter, and they couldn't find the person guilty of accessory after because it wasn't available.
He wasn't charged with accessory after?
He was not. He was originally charged before his police interview, but he was never indicted on accessory after. So that's not
So
something.
your view is that he can't be retried on anything. Is that right?
If the Commonwealth wants to bring a new indictment,
You don't think there's a double jeopardy problem with a new indictment for a different offense?
It's not there might be other issues. I think Commonwealth versus Mills in this court's decision talks about some of the problems that might arise. That's under new theory. The Commonwealth might have difficulties. There would obviously be defenses to it, but I don't think that there is an automatic preclusion because it's a different offense. So, Your Honor, so obviously there are other issues in my brief. I would rest on my brief for anything else unless there are further questions.
I have a quick question.
Sure.
Yeah, of course.
On the 3:11 p.m. text, you got a vehicle equipment.
Yes.
Are you arguing that that was not authenticated or that it was hearsay or something else?
For the third argument, it's argument about prejudice versus probative value. I think that it was authenticated in that it came from the phone that was found in his car that was associated with his number. So I don't think that that ends up being there wasn't an authentication problem. And below, they didn't argue hearsay either. The issue boiled down to whether or not it was unduly prejudicial, and that's the issue that was presented in the brief. And again, I apologize to the court if I got the record wrong.
Thank you. It's totally fine. Thank you very much. Very good argument. And we will hear next from maybe Attorney Jordan.
Good morning. May it please the court, Darcy Jordan on behalf of the Commonwealth. With me is the trial prosecutor, Julie Hodgens, and I'd like to acknowledge the family of Dennis Mejia, the victim who had succumbed to his injuries, who are watching on the live stream. I guess I should start with the record. The court has the record correct, and I can turn your attention to Record Appendix 60. And as Justice Grant and Justice Rubin described it, exactly, there was a yo by Hallow, yo in response for the defendant moments later, and then about 20 minutes after the murder, how you doing? And just to short circuit, the Commonwealth agrees with the idea that this is somehow acknowledging the defendant's involvement in this crime and his fleeing from thereafter. But I think we should start with that as far as the Commonwealth can discern is that with Cataldo, Carlton, that the SJC has now essentially delineated getaway drivers who are not present on scene, that and make a demarcation between really where they're positioned, right?
Do you think it overruled C and Baxter and Baez and Gonzalez?
I don't think it overruled. I think it put it in a bucket and categorically where the getaway driver is not on scene, does not see,
Was the getaway driver on the scene, not on the scene in any of those other cases?
No, in all of those.
So unless it overrules them, that can't be the rule, right?
Well, I think it doesn't overrule it. It distinguishes Carlton, and I think that distinguishes this case. So when we say overruled, I think what the SJC does in Carlton is say, when there's a getaway driver who drops off somebody and then drives around the block, cannot see what happens, cannot see what the shooters do, then that is too far. It's insufficient to attribute that shared.
I don't know. I don't think that's what Gonzalez says.
Gonzalez is also like those cases. So in Gonzalez, the getaway driver, or the defendant there, drops off the shooters, they all get out, and the driver drives away. And then
in order to pick up her boyfriend around the corner afterwards, not unlike this.
Just her boyfriend. But this is absolutely different in that I disagree with my sister's description that this isn't a getaway driver case. I think that's too literal and too linear about how crimes are effectuated and how intent is formed. I'm sorry, Judge.
No, I want to hear what, no, go ahead.
And I think, if anything, this case brings it closer to Watson. And I think we have even more than Watson, where we have the shell casing in the car. And I think what Sanders and Carlton do is distinguish that the maneuvering, when the driver is on scene and is present, waiting right there for them, that it can be a shared intent. And I also want to point in Carlton, which cites for Robinson, that talks about when that driver then knows that his joint venturers are armed, that the continuation and furtherance of that joint venture can be used to evidence shared intent. And that's what we have here. It's not as if this is a getaway driver in C, Baxter or Baez, that drops somebody off. And really actually in Sanders, they talk about this, is that, well, when someone gets out of the car, the driver can't be imputed to what they're going to do. And I think when we look at what this case has, and although I do think there's additional evidence to show joint venture, but if we just look at the video and how the car is being operated, we have the car come and down Westminster, and I think it's relevant of how this road especially is shaped. It's a U shape, and the murder happens at the bottom of the U. So before the defendant gets to the corner, if you will, the right end of the U, the shooters get out. And what happens then is the shot is fired within the car, then the defendant turns the corner, and I argue make and have a straightaway getaway. He doesn't leave, he doesn't take off, what he does.
Just like in Gonzalez.
No, this is
not like Gonzalez. He goes around the corner, maybe to wait and pick up these people.
Well, I think here what we know is that he's sitting there waiting, idling. You see the brakes being effectuated, and he's waiting, and because we can infer, he knows it's a blitzkrieg. He knows that it is unleashing of weapons on suspecting victims, and he's going to stay there because he knows it's going to be brief.
Okay, so let's leave Carlton to one side, because sure. I think I disagree with you that it changes these earlier decisions, and I think it would have to, in order to stand for the proposition that you're saying. So let's leave it to one side. before Carlton, under all the other cases, do you agree with the following? Merely dropping off and then waiting and picking up shooters is insufficient by itself to demonstrate the requisite intent?
I'm going to give the lawyer answer if it depends, but I think there's a distinguishing factor in those three cases, and it is that it is done that driving, the shooting is done outside the presence of the driver. And if I can read from
It's
Carlton.
also done, I mean, the cases that came out the other way, it's actually done from inside the car. Carlton is inside the car. There's another drive-by shooting where the maneuvering of the vehicle is essential. I mean, we can look at Carlton. It doesn't flatly say what you're saying. It then lists other additional pieces of evidence, right?
Well,
and I don't think it would do that if it was saying just dropping off is enough.
So I
Dropping off
think
and picking up.
Carlton and Sanders is the appeals court case that Carlton relies on. But I think when we're only talking about those cases, we're also not talking about Watson, which I think is most on point here, where the driver in Watson drives up down it's a similar situation in this, that it's a one-way street where no other cars can get blocked, right? So there's an inference of a facilitation. The shooter gets out, shoots the victim in that case point blank in a car as Watson is on scene. And I think there is a distinction in all of these cases that talks about the driver seeing and being present during the duration and continuing to facilitate that. So I think that is extremely important and distinguishes Carlton saying, and if I could just read.
So you're saying that because he saw the shooting, and obviously we'll have to look, and I'll have to look at the case law to see if that's really an accurate distinction, you know, that with that it's adequate. And so that's, I take it that, well, it is, I think, the central piece of evidence here, right? I want to talk about what the other things add or don't add.
Sure. But if I can just add a period to the end of this point, because
Sure,
I do have Carlton right here, and it's obviously this is still a slip opinion, so it's 15, and it says about Carlton, and I don't disagree. We obviously the shooter in Carlton with the laser is different from this case, but I think it stands for the same proposition of knowledge can be imputed to the driver. But it says this case is thus distinguishable from those in which we've concluded there is insufficient evidence for shared lethal intent, where the defendant merely acted as the driver of the car and with a passenger out, and then it's a dash, outside the presence of the defendant committed the shooting. Those cases do not involve the defendant who drove a car while shooting took place in his presence. And then here we go, from within the car itself. And
So does that issue come down to whether or not we can infer from the Greenwich Street video that the driver of the Fusion could see the flashes?
Yes, and I think, well, and again, I keep coming back to Watson, because I think Watson, there was shared intent. And
I don't see how seeing gunshots after people get out of your car, and I understand that you say the shell casing means he was in the car, but we have the video. I don't see what that adds. Once the shooting begins, the period for his shared intent is over. He has to share it as he's dropping them off.
I don't disagree with that, but I think based on what he does next, there's an inference that
And Carlton also goes on to talk about maneuvering the vehicle. This is like Sanders, Justice Kafka writes. A reasonable and strong inference from the evidence, it says, was that he positioned the car so that the occupants could attack the victims from inside the car.
Right.
Okay, well, there's no such maneuvering in this case.
I disagree, and I don't disagree that we're talking about what was formed beforehand, but I do disagree with saying what happens thereafter doesn't color, inform, and reasonable inference can be made thereafter, because here we have a defendant that he doesn't drive around the block. Again, remember this is U-shape. He stays there, idles, it breaks, because he knows that it's going to be an ambush, and he needs to be readily waiting feet away.
I fully agree with you. Look, when I first I watched that video many, many times. When I first watched it, I thought, he drops them off, he goes around the corner and waits for them. They obviously don't know that he's going to be around the corner because they first just run back to where they were dropped off, the shooters, and then they go and get in the car. But still, he's around the corner. It seems obvious that he's waiting. I might have thought, well, so he had the shared intent. He's the getaway driver. He knows he's supposed to wait for them. They must be doing something where they're going to have to get away quickly, although whether it's shooting or not, I'm not sure, but still. But then I read all these cases that seem to say to me, that's not enough. That I think that's, maybe I'm wrong, I think that's what Gonzalez says, basically.
Right. But Your Honor, Watson addresses Gonzalez, and I think if we look at Watson, this is very close to Watson, and I think, actually, this is discussed in Sanders, that talks about an inference can be made of multiple weapons. My sister calls it dicta, but I think every point in these cases, the aggregate is important. And I think what we have here is that in reasonable inference be known that he knew that they had weapons, because otherwise, why would he stay blocking on the bottom of the U on a one-way street? He knows it's a blitzkrieg. He knows he has to be
he's waiting.
Right, but if it was, right, because in Sanders, they talk about getting out of the car and someone leaving the car, and this idea of temporal and physical distance of the driver and the shooters, that's not what we have here. It's not as if there's a multitude of ways this ambush could have happened that would warrant this driver to leave. It's inconsistent with any other type of attack except for the attack that happened here with multiple weapons, and 17 rounds unloaded in 5 seconds. So to somehow say that maybe he didn't know, I think it's frankly not a reasonable inference. And we're like most favorable of the Commonwealth. It's not a reasonable reading of the law, the facts, and common sense. So I think I suggest that this is not that bucket of cases that I think Carlton, and I don't think Carlton overturns those cases. I just think it says if there's a case where the shooter is not present, it's treated differently. That we can't. It's too far of a stretch to infer that intent, and I think that is not what we have here. This is more akin to being on. It is on scene. It is akin to Watson, and I suggest it is more than Watson, where we have the shell casing, and then if again we could turn to the case Robinson that talks about once the driver knows his co-venturers have weapons, that the continuation and furtherance of, and I think that is indicative of all the other evidence that I know we didn't talk about, but before, after, during, in his maneuvering of the car, indicates that furtherance, he knew what the plan was. That plan was already hatched, that destination, those targets were already hatched, because otherwise it doesn't work.
There's no evidence the destination, he was directed by one of the shooters. Turn here, go there, and so forth.
Right.
He didn't know where to go.
I mean, the Commonwealth argues that the silence in the car is this clandestine plan that was hatched. This wasn't the two people getting in the car after the defendant leaves and they're talking about getting something to eat or this hangout. I'm
not talking about that. I'm saying that he was given directions. He did not know where to go. He was directed by one of the shooters. Isn't that the evidence?
I don't necessarily think that. There's nowhere else to go in this bottom of the U. And I think that's why this case,
I'm talking about getting there. I mean, once he's driving down a one-way street or whatever it is, then he's on the street. But I'm saying to get to this location, am I wrong that he needed?
I don't think it's meaningful to say he didn't know exactly the name of the street or where he's going. What's meaningful is that he's agreeing with his armed cohorts to go basically ambush and execute people on the side of the street. So I think that to somehow say stop, go, I think there's other evidence to suggest that recognizance was done without the defendant in this case. So, but I don't think that eviscerates, mitigates, or draws away from all the other reasonable inferences in light most favorable of the Commonwealth can be drawn from this. So I don't know if the court has any other questions on that point.
I have a question about the supplemental record appendix. There's a map in there of the area of Westminster Street. It's at page 44 of the supplemental record appendix. But I don't see an exhibit sticker on it. So my question for you is that from the record or is that from the trial prosecutor's file?
I'm sorry, is that my appendix, Your Honor?
Correct.
I would have to, unfortunately, I have the defendant's appendix with me, not mine. I'll clarify that and either resubmit or...
No, my question is, from the transcript, it appears that there are other exhibits that would be very helpful to us in understanding how the location fits with the video.
Okay.
For example, Exhibit 275 is referred to repeatedly. It's a map with a key about where all the cameras are.
Okay.
Before you file a brief, any brief, you should go to the clerk's office and stand at the counter and get all the exhibits and look through them and take photocopies from the clerk's office of the exhibits with the exhibit stickers that the trial prosecutor put into evidence. This is not particularly helpful.
Okay.
And there are other exhibits, like, for example, the exhibits marked for ID of the interviews of the different defendants. It would have been really easy when you went to the clerk's office to just take copies of those and put them in the supplemental record appendix. Every time you file a brief, you should look at all the exhibits.
Thank you, Your Honor. And that makes me think that that is an exhibit, because I know I did correspond with the clerk. So I apologize that the sticker.
Go to the clerk's office
yes.
and look in person. It's not enough to say, based on the transcript, what you think is relevant.
Okay.
You see things all the time when you're standing in the clerk's office that were marked, that were written on by a witness that's not necessarily clear from the transcript.
Thank you.
And you do not need to do anything now unless we issue an order asking you to. But in future, always, always walk across Cambridge Street to the clerk's office.
Point taken. Thank you. I see that I'm on red.
Time has expired, but I've taken a huge amount of your time, so if there are more questions, no? All right. Thank you very much. Very well argued.
Thank you, Your Honors.
And the case is submitted. We will next hear our third case, just to give everyone a heads up. After that case, we will take our traditional mid-morning break. The third case is number 25862, which is Commonwealth versus Garcia Rivera. We will hear first from Attorney Kahanowitz.
Thank you, and good morning to the panel, Your Honors. I'm Attorney Kahanowitz. I'm the counsel for the appellant, Carlos Garcia, and may it please the court. Your Honors, this is what I believe, a short and only one issue available. There was a violation of probation found by the judge on new allegations, which was null pros, I'm saying it right. And then 2 weeks later, we had the probation violation hearing, and the judge did not use the proper standard for a probate violation. As this panel knows, the standard is a preponderance of the evidence.
What do we do with the fact that at page 21 of the record appendix, the judge checked the box that said the serious of the new offense that has been proven by a preponderance of the evidence?
I understand that, but on the record, in his transcript, and when he gave out his order, he did check the box. I saw that now. When he gave the order, she specifically said, "You violated the terms of probation. I am including the new offense because it's probable cause that you were arrested on a new offense." And I cite Commonwealth versus Engelking, if I'm pronouncing right, Engelking, which again, 9 months ago, this court, on very similar language, found that this was not the proper standard. The district court judge in that case found, I find there's a probable cause for the new offense. I find the new offense to be in violation of probation. The language in both the case at bar and the case that this court has decided 9 months ago is identical. There is no ambiguity in that, the way that the judge presented this. And, as my brother alluded to in his brief, she never ever mentions a standard throughout the whole transcript. There's nowhere in there that she said preponderance of the evidence. This is as clear as day. It was an error. In fact, in Engelking, the Commonwealth conceded there was an error, and they reversed the violation. I'm asking this court today to do the same thing as was done in Engelking. That's all I have to say.
All right, very good. Thank you very much.
All right.
Very helpful. We will hear now from Attorney Lynch.
Good morning, Travis Lynch for the Commonwealth. And just because the judge said a single time during the course of this BOP proceeding doesn't mean that she actually applied the probable cause standard. And when I was preparing for argument, I noticed the exact same thing that Justice Grant pointed out in the beginning of defense counsel's argument, and I apologize for not putting that in my brief. The judge never actually says, I find there's probable cause to believe that the defendant violated the conditions of his probation, which seems to be what happened in that unpublished disposition that the defendant cites. Instead, she says, I find that he violated his probation, and then how I read the transcript indicates she's trying to explain why she's going to consider the criminal violations when crafting a disposition of the sentences once the violation has been found. Given that this was an admission to a violation of probation, the defendant agreed that he stipulated that he violated the conditions of his probation. He stipulated to every single one of the violations alleged in the notice of violation, which included the criminal counts. So there just is no basis in this record to say that the judge actually applied the wrong standard, especially when you consider the form, for whatever the form is worth. The Juzba case is a case in which the judge referred to in passing to the probable cause standard, but it was clear on the record that the judge was convinced that the defendant had violated the conditions of his probation. Unless there's anything else, I'd respectfully request that you affirm.
I see no further questions either. Thank you both very much.
Thank you.
The case is submitted. We will take our mid-morning break and we'll return in 10 to 15 minutes. Good morning again. We will continue our session with our fourth case. This is number 25524. Of course, it's partially impounded, which includes the names of the parties, so let's use initials. And this is captioned BT versus TT. And we will hear first from Mr. Pabian.
Members of the panel, may it please the court. Michael Pabian for Appellant TT. There can be no doubt that the probate court's finding of abuse was significantly predicated upon the email introduced at the contested hearing from TT's divorce counsel to BT's divorce counsel. The probate court said of that email, and I quote, "It's a threat and it's interference of a witness's testimony, completely inappropriate. It's intimidation, it's a financial threat, and it's coercion, full stop. But there is a glaring problem, an utter lack of record evidence that TT directed or caused his attorney's statement that the probate court relied so heavily upon. To his credit, BT's counsel interjected at the probate court hearing in an attempt to make that clear. BT's counsel said, "This is a statement by counsel. I'm not suggesting that counsel was threatening. I'm not suggesting that these are the words of TT either." But the probate court remained unswayed, repeating.
So let's say we disregard the March 31st email. Before that was even sent, we had a different probate judge issue an emergency restraining order on these facts. Wasn't there already enough in this record to show abuse?
We submit that it wasn't, Your Honor. First of all, the emergency order did issue from a different judge, but of course that was an ex parte proceeding at which TT had no opportunity to participate, and I don't believe that at the contested hearing the probate court was permitted to, essentially rely on the fact that a previous order had issued.
Could she rely on the affidavit that was submitted by the wife's counsel?
Yes, Your Honor. And we believe that that did not set out a case for abuse, especially, first of all, under the Coercive Control Amendment, which was effective September 2024, as we note in her briefs. The vast majority of the conduct that was alleged in the affidavit occurred well before that effective date.
Well, so could the judge consider acts before December, whatever the date is, before the effective date of the new definition, that tended to show placing another in fear of imminent serious physical harm?
The finding of abuse, Your Honor, we submit the pattern that is required here under the statute needs to be based on post-amendment conduct. And
I'm not talking about
wait,
coercive control. I'm talking about abuse.
Oh, so yes, Your Honor. So it is true that. So first of all, at the probate court hearing, the contested hearing, the probate court only mentions coercive control, doesn't set out an alternative basis for its order. In its post-appeal findings, which it entered 19 days after TT noticed his appeal in this case, the judge did rely on a, quote, fear of imminent physical harm. But importantly here, as we note in the briefs, the probate court never found such harm to be serious, as is required on the face of the statute. We submit that this is not such an overwhelming case that the court can simply infer the statutorily required finding from a silent record.
If we thought the judge credited the affidavit of
Your Honor.
BT, I guess it is, and that affidavit, as noted in the whatever you want to call it, post-hearing order, written order, that affidavit asserts that BT was put in fear of imminent serious physical harm, and that's credited by the judge. And the judge says that BT's fear was reasonable. I agree with you, of course, that the judge doesn't use the word serious in several places. If we were to conclude that every act described in the, not even every, acts in the home described by the affidavit, if they put her in fear of physical harm, it was of serious physical harm, could we then conclude that that's the kind of harm that, the risk of harm that was involved in the entry of the order?
Not in this case, Your Honor. And the first thing I'd just note is going back to that email, we submit that there's no way to just extricate that from the probate court's decision. It relied heavily on that email, primarily on that email, in both its oral order and then again in the post-appeal findings. So even the crediting of BT's testimony that she was in reasonable fear via affidavit, not live testimony, was based in part on that email. Now, there may be other cases where the judge doesn't use the required statutory phrase, but the evidence is sufficient, not only sufficient to support a finding that was not made, but sufficiently overwhelming that the court might say any error in failure to recite the statutory requirements are harmless. That is not this case,
Well,
Your
when
Honors.
you say this is not this case, we've got, 1, the Best Buy smacking the hand. 2, the cornering in the laundry room. 3, the February 20th backing up against the lit stove. 4, the March 18th threats of suicide. 5, the following the daughter at the track meet and then cornering the wife against the car. 6, the fact that the professionals in the negotiation process followed the wife to her car before and after the negotiation in Florida, and on one occasion in May of 2024, the husband pushed past them and ran after the wife, and she had to jump into her car and drive away. 7, the fact that the night before she left Florida, he said menacingly that he was going to come upstairs and hug her. 8, January 25th, 2025, that he communicated with her that he could show up in the Marblehead home any time, day or night. 9, in March of 2025, he said he was coming on March 27th. Why isn't all of that abundant evidence of attempting to cause or causing physical harm or placing another in fear of imminent serious physical harm?
First, Your Honor, the timing is important here. The vast majority of that conduct that Your Honor recited, which again was alleged conduct, which as we set out in the briefs was not tested by cross-examination, which is a different issue that I can discuss later if Your Honors would like. But setting that issue aside, the vast majority of the conduct ends in May of 2024, which is 11 months prior to the contested hearing in this case.
How much did they see each other after that?
Your Honor, the record doesn't reflect that they saw each other at all, which I think is an important point to consider.
So when they're going to see each other, why might the imminence of that not make the imminent fear of imminent serious physical harm?
Well, the mere statement that he, through counsel, that he was planning to come to the home to retrieve belongings, we think is clearly not sufficient. And there's case law on that. There's the HM decision in which this court, in an unpublished order, vacated a Chapter 209 order where the plaintiff alleged that she had received over 200 phone calls, text messages, calling her names and threatening to hurt himself, and expressed his intention to appear uninvited at her house. So the mere expression of an intent to come to the home is not enough. Everything else is so temporally removed that we submit that it's not sufficient to satisfy a 209A order.
How do you distinguish Vanna V?
Well, Vanna V actually involves extreme facts, Your Honor, that I think are very different from this case. It was a marriage marred by what the court referred to as significant abuse, including the plaintiff being raped, thrown against a door, and in one instance, the defendant tried to break her arm. And importantly, unlike in this case, within weeks before the Chapter 209A application, the defendant vandalized the plaintiff's car in a very threatening way and in a really angry way. So for one thing, you have in the Vanna V case, serious physical abuse predating during the course of the marriage, far more serious than anything alleged here, even crediting the allegations. Secondly, you have a triggering event within weeks of the application, which makes the fear reasonable. And I'd just like to note an important distinction for Your Honors. The question on this appeal is not necessarily whether there would have been sufficient evidence to support a finding that the judge made that the statutory standard was met. The judge never made that finding. And we submit that this is not a clear case where the evidence is so overwhelming that the court can find that error harmless. And again, it's also impossible to extricate the order from the email, which the court, again, relied very, very heavily upon. Even after those passages that I quoted before, it cited the email twice in the written findings. The probate court asked to see the email a second time immediately before ruling, and then it was the first thing the probate court mentioned in ordering the extension. It repeated after the order issued, and I quote, "I've been practicing for 27 years. I have never seen anything like that, and if I was an attorney, I would have never allowed that to stand. That's on you, sir. That's on you."
Well, did the husband's testimony authenticate the email or his knowledge of the email, at least insofar as it seemed to indicate that he and both of his lawyers in Florida and Massachusetts had discussed trying to negotiate with the wife, exchanging her dropping the restraining order for him agreeing not to come to the Marblehead house?
Yes, for an agreement not to come to the house, having nothing whatsoever to do with this alimony issue that the probate court relied upon, the statement that was made by his attorney. So his testimony on this issue is uncontroverted. And what he says...
So if the judge had said, I will only consider this email insofar as it seems to indicate that the husband was willing to agree not to come to the house if the wife would drop the restraining order, that would have been okay?
I don't believe that's abuse, Your Honor, within the meaning of the statute. I don't believe that's coercive control, and I don't think that, I think it's a very different case from what we have here, which is the probate court takes the email without any evidence and contrary to the only evidence, which was TT's testimony, assumes, and she says, quote, "There is no way that any email is going to be sent without knowledge or acceptance." There's no basis in the record for that. It's nothing more than speculation.
Is the email a violation of an ethical rule?
Your Honor, whether or not it's a violation of the ethical rule, first of all, it's from a Florida divorce attorney.
I understand that.
It might be sharp litigation tactics. It's certainly not something that TT condones, as we said in the brief.
No, but I'm not asking that. I'm actually asking, does it violate ethics rules? I mean, the judge went sort of ballistic about this, and I understand why telling someone that it will cost them if they enforce their rights under an anti-domestic violence statute. I understand why that's not generally an appropriate thing to do. But surely lawyers settle these matters.
Yes, I don't believe it violates an ethical rule, Your Honor. I can't think of one offhand. It's not something that I've researched. And we do submit that even overlooking the lack of evidence attributing the email to TT, which I think is dispositive, the email just did not satisfy the statutory definition of abuse, even including coercive control. Again, contrary to the probate court's characterization of the email, BT below expressly disclaimed any contention that TT's counsel was threatening BT by sending the email.
Well, what about aside from the email? We have the fact that the husband signed the parenting plan agreeing not to come to the Marblehead house, but then he repeatedly contacted the wife and said he'd come there anytime he wanted, day or night. And then he contacted her and said he was coming March 27th. Aside from whatever's in the email, aren't those, and the fact that he's been using the Ring camera in Marblehead to spy on her, isn't that evidence of not just coercive control, but placing another in fear of imminent serious physical harm?
No, I don't think it is, Your Honor. I don't think it's sufficient, and at least it's not overwhelming. I'd cite, Your Honor, first of all, the Ring camera issue was, again, somewhat temporally removed. I believe it was the prior June that was alleged to have occurred. Secondly, again, it bears repeating, these are disputed allegations which were not tested through cross-examination. But even putting those issues aside, we have the Brown v. Crimmins case, an unpublished opinion, where this court vacated abuse prevention orders, where the defendant had broken the plaintiff's windshield, twisted her...
If it's an unpublished opinion, it's not this court. It's only a panel of this court, so it's not binding on us.
I understand it's not binding, Your Honor, but I think that the consistent tenor of the unpublished decisions is persuasive, right? Because it's what panels of this court have decided on facts that we submit are not only similar, but more extreme. Brown v. Crimmins, HM v. MS, and there's also the Carroll case, which is a published decision, finding that the defendant's persistent phone calls and other unsolicited efforts to contact the plaintiffs did not constitute abuse. Unless the court has any further questions on that issue, I'd like to very briefly address one additional issue, and that is that all parties agree that the sua sponte extension of the temporary order for 2 years after the first contested hearing was unlawful. The statute sets a maximum term of 1 year. Accordingly, the order should, at minimum, expire on April 2nd, 2026, and to avoid rendering TT's appellate rights illusory on this issue, we respectfully request that the court at least partially vacate the order prior to that date. Your Honor, may I say one more thing about the retroactivity issue before I?
Go ahead.
I just point Your Honor to the Welch case regarding the criminal harassment statute, where the Supreme Judicial Court held that to consider the pre-statutory incidents of harassment when determining—
What's your best case that says that the ex post facto clause applies to a statute that's not criminal or penal?
We don't contend that the ex post facto clause applies, Your Honor. Welch was decided based on the presumption of retroactivity, a presumption against retroactivity, which we believe is dispositive here. Unless Your Honors have any questions, I'll rest on my briefs.
See if anyone does have a question. No? Thank you very much. Very well argued. We will hear next from, I should be able to do this by now, by Attorney Setterbo.
Good morning, Justices. My name is Robert Setterbo. I represent the appellee BT in this appeal taken by TT from a 209A abuse prevention order. May it please the Court, except in one respect, which my brother just alluded to. We asked the Court to affirm the 209A, which was not an abuse of discretion based on the record. Rather, it was rightfully supported by a preponderance of the evidence contained in the record. The initial ex parte 209A was granted on March 26th. The extension on April 2nd, 2025. This is after a two-party noticed hearing where both parties appeared and were represented by counsel. I represented BT at both the ex parte and the extension hearing. I concede that the 209A should have been limited to 1 year from the first extension hearing, but on that issue alone, the wife seeks remand rather than vacating, because if the second year is vacated by an order of this court that is entered after the 1 year period from the first extension has expired, then the wife will be left unprotected. This should be rescheduled at a minimum. Beyond that singular issue, Your Honors, we ask that the court affirm the 209A. Specifically, the court entered written findings of fact on April 22nd, 2025, in which the court credited wife's testimony via affidavit in its entirety, including wife's testimony that the husband attempted to cause her physical harm and placed her in imminent fear of serious bodily harm. This finding meets the first two definitions of abuse as defined by 209A, Section 1A and 1B, and these are the traditional definitions of abuse under 209A. The court found numerous incidents that, Justice Grant, you listed off, that some of them, that represented physical violence and threats that placed wife in imminent fear, including non-exhaustively cornering the wife multiple times in the laundry room, pushing her against the washer, blocking her from leaving the room, slapping her hand at the Best Buy, slapping the phone out of it, trapping her so she could not escape, pinning her against a lit stove and not allowing her to move, Your Honor, physically backing her into walls, and threatening to come to the home where she lived imminently, repeatedly, and stating that he could come day or night. That was the imminency, Your Honor, that led to the emergency ex parte applied for on March 26th. The court credited the wife's testimony that the husband isolated the wife from friends, relatives, and other support, deprived her of basic needs, monitored her activities, communications, movements through technological means. This finding meets the fourth definition of abuse, defined by 209A, Section 1D, which was the coercive control amendment that was included as a definition of abuse September 18th of 24. And in extending the 209A, the court expressly considered the wife's description of a pattern and practice of physical intimidation by the husband throughout the marriage. The court found that wife's fear of imminent physical harm and coercive control was reasonable, and that the 209A was necessary to protect the wife from coercive control and her fear of physical harm. Now, the husband argues that the probate court erred in reliance upon this email sent by husband's Florida counsel to wife's Florida counsel, which is where the divorce was ongoing, 2 days before the 209A extension hearing. Husband objects to this email in two respects. that the court relied primarily or heavily on it, and this argument fails by a simple review of the 27-page transcript. Of course, there was discussion at the hearing because I introduced evidence of this email. I got it shortly before the hearing, and the court needed to know about it because it occurred after the ex parte hearing. It was new evidence that the court needed to consider in extending the order. I introduced this, and the court found it quite impactful, interpreting it immediately as a threat. It was obviously damaging the husband's position, so he and his attorney spent substantial time arguing to mitigate it. Husband's counsel even conceded that the email was relevant to the ongoing divorce case in the record. But attempting to secure wife's dismissal of the 209A cannot be relevant to the divorce case, at the same time not relevant to the 209A. It's the matter at issue at the 209A hearing. And notably, the court's written findings mentioned the email only once at paragraph 17. The first 15 findings mention all the different items credited to the wife from her affidavit.
Did the email violate the ex parte order?
Did the email violate the ex parte order?
Yes.
No, Your Honor, I don't believe it did. I believe that it was a communication through counsel. I believe it was sent with husband's knowledge. It was sent with his intent. He didn't.
I'm not asking you that. We'll get to that in a second.
Yes, Your Honor.
But you say it was sent after the ex parte order. Now, of course, they had ongoing divorce proceedings in Florida. Ex parte orders, I haven't looked, at least during argument, I haven't looked at the order here. Did it not prohibit any contact, direct or indirect, by the husband to the wife, or did it include a carve-out for pending legal proceedings? Or
Typically in these proceedings, Your Honor, counsel is permitted to communicate with other counsel.
Okay.
Okay, but you know, I think there's a limit to appropriate communications here.
Now, you also say that husband knew about it before it was sent.
Yes, it's in the record, Your Honor. The wife's counsel's the husband in his first paragraph of argument, because the husband is permitted to argue himself. I believe that is on page 19, Your Honor. I can get the transcript up momentarily, but he begins in his exposition to the court, which spanned 5 pages, Your Honor, that he had a conversation with his Florida counsel and his Massachusetts 209A counsel before that email was sent to wife's Florida counsel. And this, Your Honor, is in all candor, case in point, that he had knowledge, that he had intent, that a message was communicated to her divorce counsel in Massachusetts. Candidly, if they're asking for a dismissal of the 209A as her 209A counsel, I think that communication probably should have gone to me, but it didn't, because the intent behind it was to put her in fear of losing her livelihood and the financial insecurity that is a component of the coercive control definition. Now, Your Honors.
To the extent that the husband is arguing that the pattern of coercive control can only consider events that happened after the statute was amended, could some of those same events be relevant to placing in fear of imminent serious physical harm?
Well, Your Honor, I don't want to concede that the court cannot consider events predating the amendment for purposes of a coercive control abuse definition. However, to answer the latter part of your question, yes, the court can absolutely consider historical events of abuse in determining whether or not there is there is physical harm presently or a serious imminent threat of physical harm, fear of same. So the court, in entering its written findings, I want to note that it expressly considered the totality of the circumstances here, including the email, when making its decision to extend the 209A. The second piece that the husband objects on the email, Your Honors, was stating that there's no evidence that he directed the email, so it should not be considered. Now, I pointed, Your Honors, to a piece of the record that indicates otherwise. It's, I believe, it's page 11, line 18 of the transcript. I don't have the citation to the record appendix at my fingertips, but he does describe.
Oh, I've read this. He says he talked to the attorney about sending an email that said something different and was then surprised by what the attorney said.
Your Honors, the court clearly discredited his recounting of that. The court, he
Yeah, but
confirmed that he had...
discounting it isn't affirmative evidence of the opposite.
I appreciate that, Your Honor. But he does acknowledge that he had a meeting, that there was to be a communication, this is with 209A counsel present, and divorce counsel, that that communication would be made to wife's Florida divorce counsel. And, Your Honors, the husband admits here that there is knowledge and there is an intent to transmit the message. Now, whether or not the court believed that the husband didn't know that the contents of the message would contain that threat, I think is a determination that was within the court's discretion, and the court did not credit the husband's testimony.
Okay, there's no affirmative evidence. You can discredit him all you like, but unless somewhere there's some evidence that he knew that it was sent with that statement in it, how can the judge make a finding? It'd be unsupported.
Well, in the first instance, Your Honor, because the attorney is his agent. He's met with him.
Do you have a case where abuse is, 209A order, finding of abuse is based on a communication from counsel for one party to counsel of another?
No, I
Don't
don't.
you think that might open up a big can of worms?
I sure do, and no, I don't have that authority. But I can say that in support of its finding of coercive control, the court found that the husband was an attorney himself, okay? And he knew what the communications would be like between, well, the court didn't make a finding. I think it's reasonably inferable that the husband would know, based on his conversation with his own counsel, what would be communicated to wife's counsel. And that wife's counsel would then communicate it to wife. And that blaming, victim blaming of her, saying it's her fault that should something happen to his income, and it would be a shame if she didn't get any alimony, is precisely the type of language that did place my client in further fear of imminent harm, Your Honor.
Let me ask.
No,
Sorry,
yeah.
good.
Go ahead.
I have a couple questions for you about the coercive control part of the statute.
Yes, Your Honor.
The words pattern of behavior. So the issue is how many events do there need to be to make a pattern? Hypothetically, we had a scenario, not these facts, where husband demands that wife direct deposit her paycheck to an account that she doesn't have access to. And she agrees to do that, and she does it on one occasion. But the marriage continues for 20 years, and every pay period, she doesn't have any control over her funds. Is that a pattern of coercive control, even though the husband arguably only did one act?
I think the question actually turns on intent, Your Honor, because the coercive control statute requires an intent. And, you know, what you're describing there is typical in a marriage where parties might, you know, share a joint bank account, and, you know, one person has primary control over it, and if funds are deposited into that and a relationship then deteriorates and action is made, and candidly, Your Honor, there's, you know, a standing order rule 411, I believe, that prohibits any transferring or encumbering of funds. You know, there could be an argument that that is a contempt. I don't know if it would be coercive control, Your Honor. I think that there's probably a more insidious backdrop to what the court intends, or what the legislature intends, when it comes to asking that a coercive control finding be made. And in this instance, in this case, you see facts rife that justify such a finding, where there is absolute control, there is gatekeeping, there is threats to withhold and evict, there is evict the wife and the children from the home. Your
I
Honor.
have another question about the statute, speaking
Yes.
of what the legislature intended. On the definition of coercive control under Part B about the single act,
Yes, Your Honor.
the legislature says a single act intended to threaten, blah, 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 or have a reduced sense of physical safety or autonomy of, one, harming or attempting to harm a child. That doesn't make sense to me to say autonomy of attempting to harm a child. And my question for you is, do you think that's a typo for or?
No, I don't. I actually think that that Part B is what you're referring to here, correct?
Yep.
That the single act that causes this feeling of physical safety or reduced physical safety or autonomy is specifically one of these three instances.
Okay.
That said, Your Honor, my time is going yellow, and so I would like to move on just briefly to one topic that my brother raises on behalf of husband repeatedly, is that he didn't get a fair opportunity to be heard. He didn't get a fair opportunity to cross-examine the wife or the affidavit that was credited in its entirety. I reject that. I believe that the record rejects that. The husband had counsel. The husband is an attorney. The husband asked to represent or speak himself and spoke for 5 straight pages. If you look at just the volume of time per the pages occupied by the husband's side of this two-party hearing, the vast majority is spent by husband. There are mentions of bank.
Sorry, do you think we need to reach the coercive control issue?
I believe if you don't, the 209A still stands on physical violence and fear of imminent physical serious harm.
What about the fact that the judge didn't use the word serious? And I know your time is up, but if you could answer this.
Thank you, Your Honor. I'll answer that in a couple, in 2 parts. One, the issue of not putting serious in there at the end of the rationale is immaterial. It's at the very beginning. It's in paragraph 2 of these findings. The court found the entirety of the wife's, the affidavit to be credible, and it states at paragraph 2 that the plaintiff's affidavit states that the defendant attempted to cause her physical harm and placed her in imminent fear of serious bodily harm. So that word does appear in these findings. That it's not translated to the end in the rationale itself, I think is immaterial, Your Honor, especially when viewed in light of the entirety of the record, especially the affidavit that was credited in its entirety, that lists all the different instances of physical abuse that Justice Grant listed off in the beginning of my brother's argument. Thank you, Your Honors.
No further questions? Thank you very much. Excellent arguments by both of you. Next case we have is number 25694. This is Department of Children and Families versus Mother. This is an impounded case, so we will not use names, but we'll instead use descriptions like mother, child, and so forth. I am looking to see if we have a division of time on the appellee side, but oddly, I don't see that. Is there a division of time on the appellee side?
Yes, we're splitting time, 7.
7.5, 7.5? Okay. I'm hoping that we have that. So we will hear first from Attorney Newbill.
Good morning, Your Honors, and may it please the Court. My name is Attorney Lucas Newbill, and I represent the appellant mother in this matter. This Court naturally is very concerned with the integrity of the trial court and that the information submitted to the trial court is true. This Court, as is our nation's Supreme Court, very concerned with the state's submission of evidence that is not true. And there's a particularly strong due process right to the care and custody of one's children. And what happened in this case is that evidence was submitted by the Department of Children and Families that was not true. And the court relied on that evidence heavily. The Department of Children and Family at trial submitted an exhibit, which was a court update report, which department submits throughout these cases. And within that report, it's stated by the Department of Children and Families that, that the social worker received toxicology screens from one of Mother's providers
So your brief
yes, Your
goes
Honor.
on at length without any citations to the record, which makes our job really difficult. I'm assuming the toxicology screen you're talking about is at, I think it's volume 7 of the RA, page 88.
Yes, 92, but yes, the reply starts at 88, I believe.
So that says
Sorry, 88,
norfentanyl
yes.
1.0 positive. Are you saying that that's wrong?
No. So that page, and also if you move on, if you look at, what's more helpful is page 91, which is similar, but it indicates a positive for fentanyl, right? But when you look below that, the sub-testing for fentanyl, it distinguishes fentanyl from norfentanyl, right? And if you look below that, there's the fentanyl notes that says that norfentanyl detected is consistent with the use of the drug fentanyl. Norfentanyl is a metabolite of fentanyl. So fentanyl is converted to norfentanyl within the liver. And liver function, obesity, chronic use,
So
all
are you
impacts.
saying this exhibit was inadmissible and it was improperly admitted? Or are you saying there's ways that the Mother's Council could have mitigated or, impeached the meaning of this exhibit?
Oh, I mean, this was not admitted. This exhibit was not
Okay.
admitted, Your Honor.
So all we have is the testimony of a social worker or somebody or some report that says she tested positive for fentanyl. And your point is that's not true. What she tested positive for is norfentanyl. Now, we might say that's harmless, but you have this case report of 3 pregnant and postpartum women who test positive for norfentanyl, although there is some risk, that report says, that they were lying about having taken fentanyl, but assuming they were telling the truth about their sobriety, it was something like the longest one, I don't remember, 249 days or something after.
194, yes, Your Honor.
This. Okay, so let me ask you a couple questions about that. Was she postpartum?
No, Your Honor.
Okay, so you would need some expert evidence, presumably, that this norfentanyl reading may not have been, or maybe even likely wasn't, I don't know, that this test can't show by even a preponderance of the evidence that someone took fentanyl. A mere norfentanyl reading 200 days after admitted, right? You'd need that, and right now we haven't seen that. Am I right?
Well, Your Honor, it's not the mother's burden, right? I think that the department needed
Well, that's
an
why I
expert.
just said, well, I certainly think the department could have used an expert, yes. And maybe that's your answer. Maybe the answer is, without an expert, we don't know what this means. Although you haven't presented anything that really tells us, we don't know what it means in a non-postpartum person.
If I may, Your Honor, I think that study, although that study was on postpartum women, the study was explicit in stating that chronic use, liver function, and obesity.
It's not a study. It's a case report of 3 cases. I don't know how many tens of thousands or millions of people have tested positive for fentanyl and norfentanyl, both. This is a case report of 3 women, postpartum women, with this apparent phenomena. I'm not saying it's nothing. It's obviously something, you know. But I don't know what its significance is for...
Sir, Your Honor. Well, I think it's important that medical professionals are putting together a report stating that the reliance of norfentanyl is unreliable in determining last use, and we have a judge who made a determination of last use without any expertise.
All right, let's say that was an error, ineffective assistance, prong 1 of Safarian, not to look at the actual tests, not to notice and understand that the norfentanyl positive, fentanyl negative might mean something, not to object to the erroneous admission of erroneous evidence saying they were tests for fentanyl. Let's say all of that fell below the standard of a normal, fallible attorney, whatever we say.
Yes, Your Honor.
Didn't the judge's conclusion that mother's substance abuse was not under control despite her claim of sobriety rest not only on the fentanyl test, but on the ongoing abuse of prescription drugs as indicated both by her inebriated demeanor and by pill counts and pill-seeking behavior for muscle relaxants? And so how can we find a substantial risk of a miscarriage of justice if that's our standard?
Well, because I don't think that is the standard, Your Honor, for this under NAPE, which I apologize for the late submission of the case, but I sometimes I find these and concepts and cases easiest when I'm preparing for oral arguments. But when the state submits false evidence and is made aware of it as they were made through my 60B motion and fails to correct it and has a report stating that she tested negative for fentanyl and tells the court that she tested positive, which if she tested positive for fentanyl, she used, and so she lied about her sobriety date, right? In the criminal context, that judgment has to be reversed if that evidence even may have impacted the judgment. And here, that she tested positive for fentanyl in March, as reported by DCF.
Is this in your brief? I don't remember seeing this argument in your brief.
No, Your Honor. It's my citation in the 16L letter.
Okay, well,
correct. In my brief,
let's look at your, and it's not a new decision since your brief was filed, right?
it was the decision that I cited is from 2025, and it was before I filed
Before
my
the
brief,
brief was
Your
filed.
Honor. Yes.
So are you conceding that there's no substantial risk and that we have to adopt this criminal standard for lies by prosecutors here? Is that?
No, Your Honor.
Okay.
No, Your Honor. I think that there's certainly okay. So there's certainly evidence of unfitness, right? So there's evidence of unfitness. I think under Rebecca and Benjamin, however, which I believe are both decisions from this case, where a court relies on unreliable evidence, it's really impossible to tell how the case would have come down, and that it needs to be reversed based on that reliance. And Rebecca is a great case where the court relied on child testimony of sexual abuse, which the appellate court determined was unreliable, and relied on hearsay from the child's siblings, which didn't qualify under the statutory allowance there. And so I think those cases stand for the proposition that, when you're taking the drastic step of terminating a parent's rights, that can't be made in reliance on unreliable evidence. And here we don't just have unreliable evidence, we have false evidence, right? And that argument is all made within my brief. So I don't think that the standard is merely that it had to have this alone had to have impacted the case. But that, setting that aside, the evidence of the latter use of prescription medicine, Mother explained that she was receiving prescriptions weekly, and her testimony was discredited. She had signed a release, that all of her testimony was discredited, and it's impossible to determine whether or not it was from her demeanor on the stand or other facts, or was it from this really pivotal false report by the department that she tested positive for fentanyl in March? I mean, the judge relies on it extensively.
You know, I'll tell you, this has troubled me from the beginning, because I think it seems that you're picking one small piece of evidence out of a massive record. It's a very large record. And you're kind of trying to ride in on that. But this case is about, this isn't a case about someone's sobriety or lack of sobriety. It's a case about a neglected child. And I'm not going to go into the details of that neglect, but there was profound neglect here. So doesn't that fact distinguish this from that line of cases that you're really relying on? And I think it goes back to adoption of Catherine, where Justice Cass had said, you know, when we're dealing with the case of, I'll read right what he says. In the absence of a showing, in this case it was cocaine, in the absence of a showing that a cocaine-using parent has been neglectful or abusive in the care of that parent's child, we do not think that a cocaine habit without more translates automatically into legal unfitness to act as a parent. So this isn't adoption of Catherine or that line of cases, because there is substantial evidence of neglect. So whether that neglect was caused by a lack of sobriety or mental health issues or some other underlying problem of the mom, in a way it doesn't matter because of the neglect.
So Your Honor, what I would say to that is that the neglect, so mom had the child until the child was 3 years old. And the child was taken from her because she relapsed on heroin, right? The child was neglected because of her heroin use, which she admitted to at trial, right? And she admitted to using after the child was taken. She was very candid at trial, but she was very clear that her sobriety date was September 19th of 2022. She attended NA weekly. She did not use after that date. And the submission and the reliance throughout, you know, I don't want to list the paragraphs and the pages, but the reliance throughout the opinion on the fact that she tested positive for fentanyl in March by the judge was really apparent, because it discredited this date of sobriety from heroin, which was the cause of the neglect. There was no evidence of neglect after her child was taken, so she had to remedy the problem, which was the heroin, which by her testimony, she was sober as of September 19th, 2022, and all of these people that her trial counsel didn't call, that I got affidavits from, testified that they had no concerns with her sobriety, that they had been her sponsor. And I can see my time is up, so if there's any more questions.
Well, again, I appreciate your argument, and you're pointing out, you know, what may be an error, but I don't think your argument addresses the underlying problem. In other words, sobriety is a moving target, as we all know.
Yes, Your Honor.
People relapse and so forth. And whether or not the judge correctly assessed whether at this moment in time the mom had reached a point of sobriety, I'm just not clear as to how that reflects on her fitness. Again, we'd have to put up blinders to all the evidence of neglect that came before to accept your argument. That's what it seems to me. I can be persuaded otherwise, but that's just my impression.
Right, but I do think under NAPE, I think that if you have a termination of parental rights based on false evidence, that there has to be a new trial, because it just sets such a dangerous precedent for the trial courts. Your Honor. Your Honors.
Okay.
Thank you very much. Very well argued.
Thank you. Thank you, Your
We'll
Honors.
hear next from Attorney Murphy.
Good afternoon. Lynn Murphy for the Department of Children and Families. The court did not abuse its discretion here in terminating mother's rights or in denying both motions, both 6dB motions subsequently filed by mother. The combination of longstanding substance abuse issues and significant mental health issues with the underpinning of the determination that she was not going to become fit. The department has been involved with the family since the child's birth. She had an open case 2 or 3 years, and then when mother continued to exhibit unparental-like characteristics, she was not able to follow through on her own medical appointments, never mind the child's medical appointments and needs which were significant. She was unable to keep the home in an appropriate, cleanly and appropriate environment for the child, and she continued to use opiates. So at that point, the department removed the child. And again, another year passes after the CMP is filed and we have custody. Mother continues, not complying with service plan tasks, not getting not seeing a psychiatrist, she did engage in substance abuse treatment, but very sporadically. She didn't complete programs. Her behavior was problematic. She continued to use up until March of 2023, and this report that my brother talks about, he neglects to mention, after this report was filed, after mother had tested positive, she stipulated to her unfitness, and the department received permanent custody of the child at that point.
Can I ask you a question about the visitation order because your time is short-ish? First of all, has a new pre-adoptive resource been found for this child?
Yes,
And that's where the child is placed now?
yes.
Okay. So my question is this. Why shouldn't the judge have held an evidentiary hearing on visitation? We have a child, a previous pre-adoptive situation disrupted, although apparently due to the mother, based on what's in the record. And now there's a new pre-adoptive resource right at the time of trial, a little before trial. When that disrupts, how can a judge figure out whether visitation would be bad or good, helpful or unhelpful, without understanding the facts around, not just by representation, but the facts around the disruption and questions like, is it because the child is actually not adoptable? Is it because of behaviors that we unfortunately see in some of these cases where placements disrupt because of PTSD and other related issues that unfortunately the children have, so that if the child were going to be in the foster care system for the rest of her childhood, or in a in a residential placement or some facility, that visitation might actually be called for. How can the judge decide it isn't without holding an evidentiary hearing?
Okay, there's many ways I could respond to that. First, I think your concern about changed circumstances and post-adoption visitation orders, remember, that's a right of the child. That is not a right of a parent. A child maintains their counsel and can at any time say to the judge and bring a motion that we're abusing our discretion, we want you to look at this, we want my child.
But you don't say there's anything wrong with the 60B motion.
The 60B motion was mother's attempt.
But you don't think she wasn't allowed to file it because of standing or something, right?
No,
Okay.
I'm just saying there's many ways to re-look at the a post-adoption visitation order. The court did not order post-adoption visitation in this case because of the disruptive nature of mother's behaviors. So what happened in the 60B motion, now, if the decree had been based in part on the pre-adoptive family adopting the child, then there would be an argument mother could have made on a 60B motion, excuse me, Your Honor, you terminated my client's rights because this child was going to be adopted by this family. That was not this case. So that is the problem that mother had in this case, because it was not her rights were terminated, and it had nothing to do with the imminent adoption. In fact, that the child had been placed in that placement just, I think it was only a couple months. It was a very new placement, and the decree did not hinge on that placement becoming the adoptive placement.
So that's how you distinguish Franklin? Because Franklin, it was a pre-adoptive placement with siblings that was disrupted, and Franklin was older and wanted visitation.
Right. There was many differences with Franklin was in a long-term home. That was part of the decree, and not only did that disrupt, but then, I think as you were noticing, he deteriorated to the point that he needed residential care. And the other part that the judge and this court found unpleasant was that the department didn't do what it needed to do for visitations, and it did not comply fully with its regulations at that point. This case doesn't have any of those factors. The department was generous with visitation, and the child, it is unfortunate that the disruption of the pre-adoptive homes, which was due in large part to mother, and this was the situation that the judge was faced, not only in termination of parental rights, because it showed the mother was not able to consider her child's best interests in any event, but the protection of the pre-adoptive family. The judge did not see how mandated visits were going to benefit this child. See, my time is almost expired. Is there any other questions the panel would like to ask the department?
I see none. Thank you very much. Excellent argument.
Thank you very much.
And we will hear finally from Attorney Katz.
May it please the court, Daniel Katz for the child. This is a case of massive neglect, and if I could just go through some of the evidence that was in the record, that the mother neglected the child, which distinguishes it from Catherine. She was using drugs right before, even though she was given some prenatal care while she was incarcerated. She then failed to continue with the prenatal care and produced a child who was a substance-exposed newborn. Not only was the child substance exposed, but had to remain in the hospital for about 20 days to get weaned off of methadone. The mother also was dishonest in terms of her inability. She kept on getting drugs that she wasn't prescribed or that the prescriptions had lapsed. And one thing that comes to my mind, which I would like to implore your honors to remember, was that with the muscle relaxer she used in March of 2024, and that's when she got into the car crash. And so this was a mother who couldn't even take care of herself because of her dependence on either illicit substances or substances that she should not have taken. It was the same drug that she used in the visit right before trial in May of 2024, where the social worker observed her having slurred speech and symptoms of intoxication. That is linked to an inability to have a stable and secure home, because the social worker noted that the home was cluttered. Not only cluttered, but there weren't any walking passages in in the room that would be the child, plus her speech was slurred. She neglected while she was pregnant. She neglected after the child was born. Due to some medical issues, she failed to attend many appointments that were necessary for the child's well-being. And this is a child with eye issues, which exist to this day, speech delay issues, and she failed to take the child to these appointments. So here we have a link, unlike in Catherine, with mother's inability to manage her own substance misuse, linked directly to an inability to provide what the statute says, minimally acceptable care. I mean, all children should be given a safe and secure home, and that mother was unable to provide for this child. I think you're right, Justice Grant, to focus on the differences in Franklin in terms of the visitation issue, because Franklin also joined in on the motion for visitation, and the judge in Franklin noticed that there was a lack of any relationship, and there was some evidence that there was a bond between the father and the child. And here you have no evidence, or I should say, no significant evidence of a bond. You look at mother's inability to focus while she was on the muscle relaxer. She was also unable to focus during visitation. A, she was late for about 75% of the visits. B, she didn't always fully engage with the child. And also the child was not always willing or able or wanting to fully engage with her mother. And so you have an example of a complete difference from Franklin in terms of the 60B motion, in terms of why there should have been a visitation issue.
How old is the child now?
The child is 6 and some, Your Honor, and you asked my sister, and if...
Please.
Okay. This child has been in this new home for 6 months, Your Honor, and it is a pre-adoptive home. And so, unlike Franklin, Your Honor, Justice Grant, this decision, there was overwhelming evidence of unfitness, and it wasn't based purely on an imminent adoption.
When did you last meet with your client?
I met, Your Honor, with my client in person on January, Monday was the 5th, so it was Tuesday the 6th. If there are any other questions.
I see none. Thank you very much. Excellent argument.
Thank you all.
Also, these are our.
Thank you all.
Oh, thank you.
These are our hardest cases, so we appreciate counsel's assistance in all of them with helping us try to get this as close to right as we can. So, thank you very much. The case is submitted. The next and final matter for this session is number 25-431. This too is a partially impounded case. We will not use the names of the parties, but can use initials. In this case, the case is captioned BM versus NS, and we will hear from Attorney Barry.
Thank you. May it please the court, my name is Kate Barry from Greater Boston Legal Services on behalf of the defendant appellant. I see my clock isn't.
Oh, the clock is not moving. Perhaps.
Now it
yeah,
is.
now it is.
My name is Kate Barry from Greater Boston Legal Services on behalf of the defendant appellant NS. This is a mutual restraining order case. Mutual restraining orders are governed by standards that are purposely high, both in terms of what the plaintiff needs to show before they obtain their order and in terms of the procedural protections that the judge must satisfy before issuing an order. For two reasons that I would like to focus on today, those standards were not met. First, there was not sufficient evidence on the record to support the issuance of this mutual order. And second, neither the judge's written findings nor any other findings supported the issuance of the order. Regarding the insufficiency of the evidence, 209A Section 1 requires a finding of abuse before a restraining order may issue. Mutual orders, such as this one, must satisfy additional stringent requirements as well. To show abuse under 209A Section 1, the plaintiff bore the burden of showing that Ms. S. had attempted to cause physical harm or caused physical harm, placed him in fear of imminent serious physical harm, caused him to engage in involuntary sexual relations, or engaged in coercive control. To satisfy his burden for a mutual order, he was also required to present evidence about who was the primary aggressor in the parties' relationship and to demonstrate that the mutual order was warranted. So to review what's on the record here, the first notable thing is that Ms. S. already had a restraining order against Mr. M. Another court had already determined that she had experienced abuse and had met her own burden. That was not in question at this hearing. Regarding Mr. M's allegations, he testified about texts, messages, and posts that he alleged she had sent him or made largely after the issuance of her own restraining order against him. He testifies that she notified him of court, that she had posted laughing about the restraining order, made private calls and texts, that she was going to threaten him and going to post unspecified content online about him. Beyond his descriptions, we don't know what was in the texts because it was never made part of the record, and this court cannot consider what may have been in those texts.
Okay, so what do we do? I've never seen, well, that's not true. I've seen some cases where there's no evidence at all,
Yes.
Although we've reversed them, you know, where the lawyers make all these representations and the judge is like, I'm going to issue not even 209, restraining orders, but just cases. Occasionally I've seen like that. But we have a case here where the evidence isn't in the record. How are we supposed to evaluate it? And what is the proper procedurally if we conclude that that's right, that we don't have an adequate record to figure it out? I mean, and it's not because the appellant didn't put the record together, it's because the judge didn't admit anything into evidence. What is the correct procedural outcome in a case like that?
I think the correct procedural outcome is to vacate the restraining order. It's a sufficiency of the evidence case. The plaintiff ultimately bears the burden of establishing a record sufficient to establish his case. You know, and I recognize that this is a case involving two self-represented litigants, and 209As are stressful proceedings. And that's, you know, our guidelines for cases involving self-represented litigants suggest procedures that the courts below can use for ensuring evidence like this is properly preserved for this court. For example, reading the text messages into the evidence would have gotten it into the record. She didn't have the option of looking at the evidence, not having it preserved, and relying on it as the sole basis of the restraining order that she entered. So ultimately, I think the court is left to consider the record that exists, which doesn't include the text messages and posts. We have Mr. M's descriptions of the text messages and posts, which do not meet the definition of abuse. For example, they don't meet the definition of the imminent fear prong of 209A, which closely approximates the common law definition of assault. They have to go beyond generalized apprehension, nervousness, feeling aggravated or hassled. And there needs to be more than just subjective testimony about fear. There has to be objective evidence of Ms. S's conduct that would have met that would be abusive. In order to meet the standard, these calls, texts, or posts had to contain particular menacing language suggesting imminent peril of force. In his allegations of threats to post something online, threats to threaten without more don't contain this particular menacing language. Nor was there evidence to support a finding of coercive control. Mr. M didn't plead coercive control. The court did not find coercive control, and of course there wasn't sufficient evidence of it. This is a particular form of abuse grounded in power and control dynamics that looks beyond just physical violence and instead considers patterns of behaviors intended to monitor, control, and isolate a partner. Behaviors that may qualify are enumerated in 209A Section 1, and for example include depriving a partner of their basic needs, monitoring activities, isolating from friends or families, controlling finances. Mr. M doesn't claim that she engaged in this behavior, and none of the conduct that he alleged fits anything that's enumerated in the statute. It's not in the statute, and it's not anything like what's in the statute. So there was not sufficient evidence of that either. Most importantly of all, again, this was a mutual restraining order, which meant it goes even beyond that. Mr. M needed to go beyond just showing abuse and show, given that she had already obtained her own order, and show that despite her order against him, he still needed one against her, and show evidence of who was the real aggressor in this relationship. And this is, by design, a high bar for the trial courts and for plaintiffs to meet. It's a recognition that mutual abuse is rare, and that that mutual abuse is rare, and also that 209A can be used as a form of harassment against victims of domestic violence, and it's to prevent the courts from being used as a weapon against abuse victims, as I would argue was the case in this situation. Here, the timing of this restraining order, weeks after Ms. S. obtained hers against Mr. M, the same day that he files a concurrent paternity case, his little digs at Ms. S. throughout the hearing, she's trying to be a detective, the son that she says I have, his suggestion that he wants the restraining order because men don't have the same rights as women in Massachusetts courts, really underscore the concerns about this being a retaliatory restraining order, and he simply presents no testimony to ameliorate these concerns. We have no sense of the totality of the parties' relationship, let alone who was the true aggressor and who was the true victim in this situation. And based on that, I would ask the court to vacate the restraining order.
I have kind of a random question about the record. There's a lot of redactions of everyone's names.
Yes.
And it makes the record really hard to follow. I feel like I'm reading the Epstein files.
I apologize. It's just the parties' names. I apologize.
Right, but is that something the probate court did or that you did?
I did that. That was
Okay.
my understanding of how to deal with the parties' names, but I understand I could have made a second volume as well.
If something's impounded in the trial court, then it's impounded here too.
This wasn't impounded in the trial court.
I see.
My instruction from the clerk's office in the past has
Okay.
been to redact, but I apologize if that was
I
incorrect.
stand corrected. The clerk's office is always right.
I apologize, Your Honor.
No, don't apologize.
It's often right.
So in addition to the insufficiency of the evidence, we also have an issue with the court's findings in this case. Again, because this was a mutual restraining order, the court was required to issue written findings that would support the issuance of the restraining order. This is important. It ensures close scrutiny of often conflicting evidence and ensures that judges meaningfully engage with the high standard for mutual restraining orders, carefully considering who's the primary aggressor and who's the primary victim. These aren't just a formality. They're an essential procedural safeguard in 209A proceedings. Under Nelson N. v. Patsy P., they need to include case-specific facts regarding the key disputed issues, and typically including what abuse the defendant has committed and why in order to prevent further abuse is warranted. This order was supported by a single written finding, that the court reviewed texts, messages, and posts made after the extension of the defendant's 209A against this plaintiff. They don't point to any particular language in these texts, messages, or posts, which I think actually goes to the court's earlier question of, what do we do with this the missing content of this? The court here had heightened obligations to make written findings about this. This wasn't even just a regular restraining order. If something was in those texts that the court was relying on, it needed to be written down in the court's findings. And so nothing in the court's findings addresses any key disputed facts, including the legitimacy of the text messages, which was contested. It doesn't say who the primary aggressor was. It doesn't say which grounds under 209A the court was relying on. It doesn't say why in order to prevent abuse by Ms. S., who already had her own restraining order against Mr. M, was warranted. In short, no one could look at this finding and deduce a single act of abuse committed by Ms. S. No one could say why this order issued, because of course texts, messages, and posts are not abusive. So as in SOMI, this court should vacate the restraining order as well based on the lack of written findings. because the written findings indicate an insufficient basis for the order, excuse me. And even if we look beyond the written findings, nothing else in the court's comments, rulings and order indicate a sufficient basis for the order.
Was BM represented by counsel at this hearing?
He was not. Neither party was represented by counsel.
So I'm still back on this question about this evidence that isn't in. Now, obviously, if it were a lawyer, it would be easy enough to say, like, you didn't move its admission. But a pro se litigant in one of these proceedings, I don't know that they can be expected to say that.
No, and I ultimately think...
I mean, it's the judge's, well, I won't say responsibility, but I'm just trying to figure out what one might say about what's supposed to happen here.
No, and I very, very much acknowledge the informal nature of proceedings, that victims are frequently coming to these with short notice on an emergency basis, often having just left an abusive relationship, and we're not trying to put a tremendous procedural burdens on them, which is why really, in this case, I think the judge was the person best positioned to get this evidence on the record. You know, the new guidelines for cases involving self-represented litigants indicate that the judge is the directing and controlling mind at trial. They should be particularly proactive in evidentiary matters involving self-represented litigants. And I don't think it had to be tremendously complicated. They could direct him to read them aloud. The judge could read them aloud themselves. Neither of those is particularly burdensome on this court. You know, and short of that, you know, I think it is a different case. Suppose the judge had said, you didn't move it into evidence, so I'm not relying on it, I'm only relying on what you said. That's a different case, that's not before the court here. But I think either way, the best practice is for the judge to ensure that the evidence gets on the record before relying on it. But given that it's not on the record, I think with the insufficiency of the evidence argument, it simply can't be considered here. And, you know, regarding the kind of procedural concerns about simply vacating it, Mr. M, it is on the appeals court docket, Mr. M did file a motion to terminate this restraining order. It's no longer in effect. So there aren't concerns about leaving him with a lack of protection at this point if it is to simply be vacated. He filed a motion to terminate it in the probate court before it came up for its extension. And finally, there's nothing on the record, written or otherwise, to indicate that the judge carefully considered the evidence to determine who was the real victim and who was the real aggressor. There's simply no record of any meaningful analysis to that effect. When Ms. S. started to testify about her fear of Mr. M, the court tells her, today isn't about you and the child, indicating that that testimony wasn't pertinent when it actually went to the central question of the case, who's the victim, who's the aggressor here. And then the court moves on to the paternity case before abruptly returning and saying, hey, hang on, I'm issuing this order. The record is simply devoid of any indication that the judge was really meaningfully engaging with this essential standard that is in place to protect survivors of domestic violence. And based on that, you know, the court erred by issuing the restraining order without that analysis. I see my time is running short. If there's no further questions, I'm happy to rest on my brief.
I see none. Thank you. Very, very excellent argument. Thank you very much. The case is submitted, and that brings us to the end of today's session. I'd like to thank the court officer and the members of the court staff for their, as usual, excellent assistance today. And we stand in recess.